Okay, so another thing that happened this year was something pretty profound. The petition for writ of mandamus.
A lawsuit filed by Dr. Keanu Tsai against President Donald Trump has been dismissed. On September 11th, a federal court judge dismissed Tsai versus Trump, concluding the court is without jurisdiction to review the claims because they involve a political question.
They go, I got it.
At a recent talk in Kalapana, Tsai explained why he sees the dismissal as a victory.
The petition for writ of mandamus was filed in Washington, D.C., United States Federal District Court on June 25th, 2018. So Tsai, chairman of the Acting Council of the Regency of the Hawaiian Kingdom against Donald Trump and all these other countries and individuals. Now, on September 11th, well, actually before September, I was actually contacted by the U.S. Attorney's Office in Washington, D.C., asking for additional time to answer the complaint. Because if the way cases work, you file the complaint, if they don't answer within a time period, they default. That means you win the case. That's how it works. So this U.S. attorney was asking for additional time to respond because she wants to address whatever. And I said, fine, no way you can falsify this stuff. This thing has gone through doctoral committees, peer review, law review. Okay, we're going through a U.S. attorney now and you found something. You found the Treaty of Annexation. That's the only way you can change this. That's the only thing. You got a treaty? No treaty. Okay, everything is true. So what ends up happening is the judge, the federal court judge, dismisses the case by an order, right, on 9/11. Oh, what a day, 9/11. Dismisses the case, and she says, because Tsai's claims involve a political question, this court is without jurisdiction to review his claims, and the court will therefore dismiss the petition. They're only talking jurisdiction, so they can't review the claims. They actually accept the factual allegations as true. See, that's what I'm getting from it. But I need the court to tell me that, not me trying to say what I'm interpreting, right? Okay, so this is what happened. In 2008, the same court in Washington, D.C., dismissed the case concerning Taiwan as a political question under Rule 12b-1 in Lin versus United States. The federal court in its order stated that it must accept as true all factual allegations contained in the complaint when reviewing a motion to dismiss pursuant to Rule 12b-1. Yeah, that is the key that just pop, open the lock. Now everything comes out. So what are those factual allegations in the complaint that was accepted as true because they dismissed it as a political question, right? The factual allegations were stated in paragraph 79 to 205 under the headings from a state of war to a state of peace to a state of war, the duty of neutrality by third states, obligation of the United States to administer Hawaiian Kingdom laws, denationalization through Americanization, the state of Hawaii is an armed force, the restoration of the Hawaiian Kingdom government, recognition de facto of the restored government, war crimes 1907 Hague Convention, and war crimes 1949 Geneva Convention. Under each of those headings is all the facts that speaks to these violations. So what they're saying is, well, a federal court can't look at it. The executive has to. Well, where does the executive go to? They go to international law. Where were we in international law? Permanent Court of Arbitration. Remember fact-finding? Yeah, perfect. This is now a statement coming from the federal government admitting that everything here is true. Anything you say can and will be used against you in a court of law. It's just which court. Make sense? Now, what I find interesting is the U.S. attorney in Washington, D.C. filed a motion, a request from this judge to allow her to answer the complaint in light of the order dismissing. Because the U.S. attorney knows that by the judge dismissing it as a political question, she is admitting all the factual allegations are true. And she wants to try to address it. And it was denied. So that means this can be now used at the UN Human Rights Council. It can be used in other cases. This is the U.S. statement acknowledging Hawaii is occupied and war crimes have been committed.